This is Matthew Rosengart. This webinar is sponsored by the Beverly Hills Bar Association's litigation section, which is chaired by Hillary Johns. The litigation section's own Alexander Rufus Isaacs created the War Story series, and I believe this is the first entry of 2021. Today's program is also chaired by committee member Rudy Lehrer, and we thank Rudy for his hard work and creativity in putting this together. By way of background, my name is Matthew Rosengart. I'm a partner at the law firm of Greenberg Traurig in the litigation department. Before moving to private practice, most relevant to this program or webinar, I started my career as a law clerk to Justice David Souter on the Supreme Court of New Hampshire, I believe in his second to last year on that court, which is where I pretty much maximized my appellate experience. It's somewhat embarrassing even mentioning it, given the appellate legend that we have here as our guest of honor. Right after my clerkship, I served as a trial attorney, and I believe Ellis will talk about certain distinctions between trial attorneys and appellate attorneys in both the civil and criminal divisions of the United States Department of Justice in Washington. That brings us to the star of today's program, who, as I said, truly is a legal legend, Ellis Horvitz. Ellis has been recognized as, quote, the dean of the California Appellate Bar and a pioneer in appellate litigation. He was the first inductee into the California Lawyers Association's Appellate Lawyer Hall of Fame. Ellis is a partner emeritus at the firm of Horvitz Levy LLP, the firm that he co-founded in 1957, which continues today as a leader in California appellate litigation. In this session, Ellis will discuss, among other things, some of the highlights of his legal career, including his clerkship with the great California Chief Justice Phil Gibson, the creation of the appellate litigation practice in California, notable successes before the California Supreme Court and I believe other courts, along with some insight into Ellis's unique approach to appellate practice. The other thing I was asked to mention before we begin is that for all attendees, MCLE certificates will be emailed, I understand, within 24 hours. And just a plug for the next session, which I understand will be March 26th, the guest will be Roman Silberfeld of the firm Robbins Kaplan, moderated by former President Michael Sohigian. Roman is going to discuss his recent massive litigation victory in which the jury returned a $269 million verdict, the largest ever in a Hollywood accounting case for his client, the creator of the TV program Who Wants to Be a Millionaire? Ellis, it's really a pleasure to have you here today, although we did, as the appellate lawyer that you are and the trial lawyer I like to think of myself to be, some prep for this. Some of this will be freewheeling. The topic, obviously, or the name of the program is War Stories, so I expect we'll hear some entertaining war stories from you during the course of the program. With that said, I thought it would make sense just to start with what you did after graduating from Stanford Law School, I believe in 1951, that led to the clerkship with Justice Gibson, which I understand was so informative of your early and frankly later career.
We ready?
Yes, sir.
Okay, thank you. Thank you, Matt. I want to mention that, first of all, that there's, in my mind, a big difference between trial and appellate lawyers. I have found trial lawyers to be more fun, to be more extroverted. The appellate lawyers, I must say that most of us, including many good ones, tend to be a little nerdish, and we still get our work done, but that's what we're dealing with. My early experience, particularly when I was still in law school, is that I knew for a certainty that I would never set foot in a courtroom. I was interested in a career really with the federal government in an administrative capacity. And indeed, I was hired for such a position by the Atomic Energy. And at that time, it was very interesting because they were talking about opening up the field of nuclear energy to the civilian world. So I wasn't hired, and there was a job freeze on it at the time. It was an economy move in the federal government, and there was a what should I call it, a freeze on any hiring in the federal government. And the weeks went by and the months went by, and the freeze did. The freeze just lasted and lasted. At this point, I bumped into the Stanford placement director. He asked me what was going on. I told him. He said, "Well, Ellis, there is an opening with the Chief Justice of California, Phil Gibson, and I would like you to apply for the job." And I said, "Oh, okay." And then I heard from our dean in the law school. He said, "Well, I've heard that Gibson is a very difficult and demanding justice, and I just want to let you know that to be sure you know what you're getting into if indeed you are offered the job." So I went to meet with Gibson, and indeed he hired me on the spot, and I went to work. Gibson was gone the first month I was there. His first wife had passed away, and he simply took a month off to really for mourning purposes. So I was, in fact, farmed out to one of his I would say permanent staff people to supervise my work. Gibson came back at the end of the first month, and I had my first conference with him. And I'd never had a conference like that before. He took a memo that I'd worked very hard on and simply tore it to shreds in a very clinical way. There was nothing ever demeaning or insulting in the way he worked. He just gave me a detailed clinical analysis of my work. And as we walked out, the attorney who was I was assigned to for the first month turned to me with a big smile and said, "Oh, he likes you." And I turned to her and I said, "My God, what would it have been like if he didn't like me?" And so excuse me. So it went. I was with the chief for a year and a half, and almost all of our conferences were like that. you like that. We never sat back and relaxed. We were on the front of the seat and on edge the whole time. But as I worked there, I learned more about the chief. Why was he so demanding of us at that time when we worked for him? I knew it wasn't insulting. It was never demeaning. But he had great ambitions for those of us who worked for him. He was using this opportunity to teach and to educate us, not only to the judicial system, but to how would I put it? To make us see how good we could be. And I understood that almost from the beginning. While I was there, I think 3 other fellows started work with him and left in short order. But I didn't, and I stayed with him. And I would put it this way: I really became a lawyer when I worked for Chief Justice Gibson. It was just that simple. There was an extra bonus at that time. The chief hired an attorney from what was Bowles Hall then, the University of California Law School. And his name was Bonnie Iturbide. Bonnie was blind, and we worked together for the year and a half, well, almost a year and a half that I was there. And it was the beginning of a lifetime friendship, so that was a bonus. But the main thing I achieved with Chief Justice Gibson was that doing our best work possible should become the norm for us. Nothing less than our best effort would be acceptable. And as I say, that made me a lawyer. And
Ellis, let me ask you, anticipating that we would start there, it reminded me of a book that during my clerkship, Justice Souter recommended that I read, and I'm going to hold it up because I think this is one of the all-time great photographs of a judge. That's Judge Learned Hand, for those who don't know. And this biography was written by Gerald Gunther, who clerked for Hand on the Second Circuit, and then became the dean, as you know, Ellis, and most of those in our audience know, of Stanford Law School. And what Gunther wrote about his clerkship, he felt much the same way about his clerkship as you do with regard to Justice Gibson, and I do in a different way in regard to Justice Souter. I obviously did not become an appellate litigator, but he wrote the following, which I think resonates, quote, "It is not surprising that for most of Hand's clerks, their year's service with him was one of the most rewarding of their careers. For some, everything that followed was anticlimactic. For all of them, the clerkship was unforgettable, a demanding, intense, intellectually engaged experience with a rare judge and human being. And for Hand himself, the clerks assured him not only close encounters with different viewpoints and modern ideas in the law schools, but above all, a zestful, ceaseless searching for answers that Hand was sure could never be unchallengeable, permanent ones," which I think speaks to his humility. So there's the balance between a harsh taskmaster and a humility, and somebody who is really a lawyer's lawyer. I don't think clerking was the climax of your career exactly, because you went on to do great things in appellate law. Maybe you could talk about how the clerkship led to your pioneering appellate practice.
Okay, I can do that. And I have a frog in my throat. Working with Gibson, I truly learned that working at my best was what I was doing when I clerked with him. And I learned more. Gibson was not only a great Chief Justice, he was just a great human being. He, excuse me, he cared about the people who worked for him. And he had a sixth sense that if anybody was having some personal problem that where he could be of assistance, he jumped in to help. He also had a marvelous sense of humor. I recall one day he came into my office. That was the only time in the whole time I was there that he came into my office. And nobody else came in because I was at the end of a hall. It was the end of a hall. It was the end of a hall. And at that time, what I frequently did after lunch, I unbuttoned my shirt and my tie and leaned back and put my feet in a drawer and worked on the opinion I was working on. Well, I must have been a sight because he came in and he immediately went and stood outside the door, and I could hear him laughing. He just couldn't control himself. I must have been a sight. And then he came in. Now, see here, it was, and a short lecture followed. Something else I did in the early years of my practice, I started teaching appellate practice at Uscc, at USC Law School. And I didn't have much practice, so I did that teaching. And at that time in the 60s, USC had a day and a night school. And I invited some of the best lawyers in town to address the night school to discuss trial practice, because I had not tried cases. And so that worked. I had the leading criminal lawyer in town, the leading divorce lawyer, and the leading personal injury lawyer. They all accepted and they all came down and lectured. And he was, they were all just mesmerized. The students sat enthralled. One of them was Raul Magana, who was just a masterful trial lawyer, and he could do things that were just amazing. And he started sending me a few appeals. He had nobody in his office who did appeals. So over the next year or so, I did about, I think it was 16 appeals for Raul Magana, and we won 15 of them. So I started getting calls after that from attorneys I had beaten, and I found that really it was easier working for the defense. For the defense, because you could bill them at the end of the month, they would send something to you. With personal injury people, with personal injury lawyers, you had to wait to get paid until after the case was over. And since most of those cases required a retrial, I was waiting along on.
And these were cases that were referred to you by, you said, people who you had success against. Is that right? That's
Yes.
always a high compliment.
Yes, it was nice. It was nice. And at that time, which was about the mid 60s or so, my practice really took off like a rocket. And I realized that I was unable to handle all of those cases. And if I wanted to, I was going to have to hire younger attorneys to help with the work. And so I started hiring, and a lot of the young clerks at the Court of Appeal, particularly in Los Angeles, called and came in to talk to me about hiring, and I decided to hire them. I had gone for several years without clients, and I figured I would rather hire lawyers and take the cases that came in rather than remain a solo practitioner. Our practice, it grew. We started with about two lawyers, and year by year, we hired more till about the time I retired, which was 11 years ago. There were probably about 30 lawyers in the office. And I would say the workload was 75, 80% appeals, and the other 25% was appeal-like, the appeal-like cases. One of them that was in our office for a long time was the micro statute. I think it was 1975. The California legislature passed a micro bill that helped the medical profession and healthcare providers with the aid of certain statutes which would limit their liability. The industry, the healthcare industry, wanted to protect the doctors because so many doctors had to quit their practice because the insurance rates had become so high for them that they revolted, and there was actually a strike of doctors in Northern California. So those clients were joined forces and hired our office to study the new statute and determine whether it was constitutional or not. And that's where we started. The work was extensive. Most of the people figured it would be unconstitutional because it made a particular kind of injury less valuable than it had been before. And the example was if somebody is hit by a car and had a broken leg, and somebody was injured by a doctor, they would have a recovery, but it would be much smaller. We argued that case in the Supreme Court 3 times. I've never had that experience before. I've never argued a case so many times, unless we went from the Court of Appeal to the Supreme Court and then back to the Supreme Court. But at this time, this occurred because there was a lot of turnover in the Supreme Court at that time. And I don't know if it's by statute or not. The Supreme Court's rule was that excuse me. The Supreme Court's had to use justices pro tem to decide the case the first time, but when it came for a second argument, they had to hear oral argument again because there'd been more turnover in the Supreme Court. And then finally, the third time was the same thing. Well, I'll tell you, by the third time I argued that case, I mean, it was really beautiful because I had heard from all the justices the two previous times. And we ended up, well, at the second time we lost 4-3, but there was a change in the court. There was an election. 3 judges were voted out, and through 3 judges were later voted out. But at this time, Joe Groden came on the court, and Joe joined the court and changed the vote 4-3 against us to 4-3 in our favor. The time it took us to get a definitive decision from the Supreme Court was 9 years. We spent 9 years taking that case through the court, and we won. Otto Kaus, who was a marvelous justice, first on the Court of Appeal, then on the Supreme Court, said that while he was on the court, he thought this was the most important group of cases that this was the most important group of cases he ever decided while he was on the Supreme Court.
And Ellis, I'm sorry, just let me ask you, and for those who aren't familiar with the MICRA acronym, that's the Medical Injury Compensation Reform Act. Let me ask you, you said something earlier that was very interesting in terms of focusing, as your firm did, which was very unusual, especially when you formed your law firm, on appellate practice only. When we were speaking before this program, there was a gem that caught my eye, which was something to the effect of one of your gems. If you give me a choice between arguing the facts and the law, I'll take the facts every single time, 100%. That's something that applies to trial lawyers, I think, as well as appellate lawyers. But why is the focus on the facts so important as an advocate, as a litigant? Can you talk about that for a couple of minutes?
Yes. In fact, I have some notes here. That's
sure.
A very next item.
And I think you've got a good story about that in terms of writing the other side's brief.
Oh, yeah. Oh, yes. I taught at USC for about 23 years. 6 years were a team taught. Justice Bob Thompson and I taught the course together. And Bob was just a wonderful person to work with. I would tell the students exactly about the facts are really everything, because the justices want to reach a fair decision. And they're going to determine it from the facts. And Bob said that he would always read the facts and almost always make his decision based on the facts. So afterwards, he would read the law to to see for sure what the cases had, but he said almost always after he read the facts, that was all he needed to do. With us, Bob said when we would file a brief in his division, when we would file a brief in his court, he would read the brief from beginning to end, knowing that after he had read it, they would read the record to be sure that it said what we said it said, but that which is a big advantage. If you have to check the record after every sentence, it's hard reading a brief. When you have confidence in the brief you're getting, you can read the whole thing through and then later check the what the fact statement is against the record. And he made that point, and I made the point that if any of the students ever had an appeal against against my firm, where we were on the other side, that if that I would agree that if they let me write the fact statement to their brief, I would let them write the legal argument to my brief. And it was that serious. I want to go back and touch on something about Chief Justice Gibson. He was a remarkable person. And when the Japanese were interned after Pearl Harbor, he was the only person only statewide office holder in California who publicly spoke out against the internment of the Japanese. Later, when I was clerking, he wrote the Sei Fuji opinion, which held the constitutional provision against that declared the alien land law unconstitutional. So both in heart and in brain, he was a very special person. Several things that are like writing tips. What you're looking for from the court, or what you want the court to think of your work, is that you are credible. If you are credible, you're halfway home to begin with. If you're not credible, you're in big trouble from the beginning. I recall an oral argument once I had in San Bernardino, and I was next on the calendar, so I was listening to the fellow ahead of me who really didn't know what he was doing. And Justice Tamura, who was a very polite, very courteous judge, stopped the fellow arguing the case and said, "Pardon me, Mr. So-and-so, you said such and such, but doesn't the record really show this?" Which was quite the opposite. And the fellow said, "Oh, no, Your Honor, it's the way I said it." And Tamura said, "Well, then you must be right, and please go ahead." And the fellow went ahead repeating the same thing. And I remember sitting there and thinking to myself, fellow, you're dead. Why are you still talking? And of course, he lost his case. So credibility is everything. I edited everybody's brief when there were about just 4 or 5 of us, but as more people came in, some of the other attorneys became editors. And the editing process, for me at least, was to read the brief through that somebody had written, make any changes that I thought were needed, and I told them that if I have to read anything in your draft, and I have to read it twice, then it has to be rewritten so that you can do what needs to be done to make it totally totally correct. And I'm reminded once that a book about the brief writing once mentioned Vin Scully, who was the who worked for the Dodgers all those years, and I frequently ate at the same table. We lived not far from each other, to this day, and I mentioned it to our maitre d', so he came over and told Vince about it, and he asked me why would they mention what it is, and what Scully had said was they asked him, isn't it true that you do so well with baseball, but you can't, you're not as good announcing other sports? And Scully said, no, that's not so. He said, what I do is I describe motion and momentum. And he said that applies across the board. And I tried to get that in the briefs I wrote and in those I edited, that when you get a brief ready to file, it has to move. And if you get bogged down, you're saying things that shouldn't be there.
And Ellis, let me go back to credibility for a second, which is something you learned from Justice Gibson and something that was a key to your success. What does that mean as a practical matter when you're asked a hard question by a justice and the answer is not in your favor? You have to acknowledge that. You have to admit that, right?
Yes, I had an example of that. Justice Trabrader was one of the liberal members of the court, and I rarely got his vote because I was basically representing the corporate America.
Right.
But I had a case, and there was a Court of Appeal decision that was dead against us. And Trabrader asked me to distinguish that case. And I immediately answered, I can't, sir. It's against me. And he burst into a big smile. And it wasn't a kind of I gotcha smile, but it was just a frank out statement that this Court of Appeal case is against me. And I just said, I think it was wrong. I wrongly decided, you're not bound by it. But it turns out we were bound by it, and we lost the case. But that was the beginning of a very, very nice friendship between me and Justice Trabrader. And we would sometimes talk about things at bar luncheons or things like that, and corresponded back and forth. And then I think one of the nicest compliments I ever got was from to Greener in a letter he sent me. So I took that letter, framed it, and gave it to my grandsons to read in case one of them goes to school.
And Ellis, you lost that case,
Yeah.
which maybe you should have done, but you made up for that loss with a tremendous amount of credibility among your peers and on the court, right?
Yeah. And what so many attorneys have done in oral argument, and they'll try to give an explanation of a case that just to distinguish it, that just isn't true, or an explanation. I remember once I had a criminal case, and I argued it in the Supreme Court, and we went to oral argument a few days later, and the opinion came down the day before our oral argument, and it was exactly like our case. And when the Attorney General's office got up to argue, I remember Justice Burke asked him, other than the defendant's spelling of his name, how would you distinguish this case from the one we just decided a few days ago? And the Attorney General was trying to distinguish it in some way and couldn't. And it was just a foolish thing to say. And I tell everybody that that's what they, that's what they should not do. I must say also, I loved going to court and arguing cases, especially in our Supreme Court. If I had been independently wealthy, I would have paid the client to let me argue. It was just, to me, that was always a great experience. And
let's talk about your preparation. As a trial lawyer, I love going to court too. One of the things that we don't necessarily love is the tremendous amount of preparation, but for any good lawyer, along with credibility, it's necessary. How long would you generally prepare? There was the old Michael Tiger, great trial lawyer from Williams and Connolly, tells the story about, 10 hours, 20 hours, 30 hours for maybe 1 hour in court or argument. What sort of preparation did you put in before a big oral argument?
When I was writing the briefs early on, in the early days, if it was my brief from the beginning, I knew the record backwards and forwards. And I would prepare fairly quickly. It would take a day or two just to bring the case current, but I knew everything about that record. As I became the editor or supervisor, I didn't know the record that well. So if I had a case, especially a Supreme Court case, I would spend days getting ready for oral argument. I'd spend a lot of time doing that. And I recall one case we had in the Supreme Court, and I checked into in Los Angeles. I checked into a hotel 2 days downtown I got checked it. I spent 2 full days, and I got a 2-room suite, so I could use one for all my books. And Mitch Tilner in our office, who's a marvelous lawyer, said, you know, here is a pleading issue. You better master it. I said, why? Why is that important? Because the case went to trial, and I can't see how any error in the pleadings is going to get us a reversal. And I went in to argue the case, and first thing, one of the justices asked me about that pleading question. To this day, I don't know why she asked that question, but Mitch had given me fair warning. And I find that I reached a point where it began to get very tiring. I had nightmares that I was arguing before the U.S. Supreme Court, and I didn't know anything about the case, and I dreamt that they were going to deliver the briefs to me the night before argument, and lo and behold, I never got them. And I had that dream over and over and over. And I said to the other attorneys, I said, I think I'm going to stop arguing cases. And that's about the time I did.
Were most of your cases before the California Supreme Court, or did you do federal circuit court arguments, or even make it to Washington, D.C. before the Supreme Court?
Yeah, I didn't make it to Washington. A few attempts, and but I didn't get that done. And I found out later that I met some of the Supreme Court specialists in the U.S. Supreme Court.
Right.
And I realized they knew their court better than I did, and I would bring them in. It was the reverse situation with the California courts, and there was a period of time I practically lived in that court where in the late 60s, I remember I got 7 petitions. We called it petitions for hearing in those days.
Right.
I got 7 in a row granted, and I didn't win them all. I think I won 4 and lost 3, but by that time you really know the justices. And in one case, I got the opticians declared unconstitutional, and that one took a long time going up. And I remember the client telling me he was kind of a little fellow, resembled, I'd say, Woody Allen a bit. And he said, this law is just unfair. It's unfair. It's unfair. And he was right. And I took that case up, lost in the trial court, won in the Court of Appeal, and then we went to the Supreme Court. And I should mention, to me, the frosting on the case was some of the great constitutional issues, and we had probably more than our share of First Amendment cases, free speech, the religion clause, and to say that I enjoyed those cases is an understatement.
Did you get a different level of satisfaction in representing an individual as opposed to a corporation? And how many individual litigants or appellants did you represent?
Oh, many.
Percentage-wise?
Oh, I really couldn't say percentage-wise because there were hundreds of them.
Right. Which did you find more satisfying?
Well, the ones, some of our cases were full-scale wars, and
I thought the wars were at the trial level. How was there a war at the appellate level?
Well, I would say at the appellate level, they were full-scale wars. Because the intensity and the issues were totally absorbing. One, we had 2 appeals. They were just marvelous cases for the Worldwide Church of God. And we had 2 cases, and both involved the religion clause of the First Amendment, and the second one involved both the religion clause and free speech. Well, you just can't do any better than that in sheer enjoyment. And about 25 years ago, I mentioned in an article that 2 cases that remain in my mind were one about the dispensing opticians law, and the other with the Worldwide Church. Oh no, it wasn't the church. There was single individuals, and we took it to the Supreme Court. I took it to the Supreme Court at that time, and the state Supreme Court, and we won. So there you had one, in each case, you had one individual against the state, and all the states bite. And we fought it up to the highest court, and my client won. I think the comment I made at the time was, when one solitary individual without influence, without connections, can take the state on and win, you've got a healthy judiciary. And,
right.
Yeah, those 2 cases were just, they were wonderful cases. That's about yes, the type of satisfaction that comes with, let's say, First Amendment cases is just overwhelming. And another time that I recall, where it wasn't my case, that was wonderfully satisfying was the Seifuji case, and which Chief Justice Gibson wrote in a 4-3 decision, declaring the alien landlord, the alien land law statute unconstitutional. And I was working for Gibson, and it was in the newspaper headline on Saturday morning, I think. I think it was, and I lived fairly close to where the court was. So I went to the court, and on a Saturday, I think a Saturday morning, and I knew where the Friday's opinions were. So I got a copy of that opinion, and I sat there in my office by myself and read it. And I was so proud that Gibson had written the opinion. I remember I sat there and read that opinion and figured, boy, oh boy, I'm working for a great man.
That's a great story. On that note, we've only got a few minutes left. The hour has flown by. I've received several comments from those in the virtual world expressing their appreciation for your time and these stories. If anybody has any specific questions, I'd encourage you to send them to me, which I should be able to view on the chat screen. And while we're waiting for any questions to come in, if any, Ellis, just maybe end with some practical tips that you may have, to the extent you haven't covered them, for young lawyers looking to get into appellate practice. You had a running head start by clerking for such a great justice, both substantively, and he taught you how to be a real lawyer, as you put it. What tips, other than scoring a great clerkship like you did, would you have for young law students coming out looking to follow in your footsteps?
Oh boy. Well, no. Number one, I would say, is look for credibility. That's the most important thing. When you come into court the second or third or fourth time, it pays off. It pays off. I would say also limit the number of issues you want to raise. Even if you have 5 or 6 reasonably good issues, try and cut it down to 2 or 3. And particularly on petitions for review. The best briefs are maybe single issue briefs. And I remember I had a case against a young fellow who was representing an injured boy against the Dodgers. A foul ball was hit into the stands and struck the boy. The young fellow against me raised one issue only, and it was a winning issue. So I told him afterwards, I said that was a very good way to go in that case. You really did a nice job. And he called me back later and he said, I really like doing appeals. Would you write me a letter telling me what you said on the phone? And so I did. And I don't think we ever talked again, but on that one occasion, he raised one issue. The idea that if you have too many issues,
right,
is sound, and you will do better if you can limit your issues.
Right.
And it's a hard choice sometimes when you're deciding to leave something out. That's a tough choice.
Ellis, we have time for just one question, and you have 35 seconds. I'll play Chief Justice here. You've got 35 seconds on the clock. We have got several questions, but to read just one, what do you think about appellate courts like the current California Supreme Court, in which Not many justices have very, very much trial experience. In 30 seconds, do you think trial experience is beneficial, and do you think a judge is adequate to sit as an appellate judge without that experience? You're retired, so you can answer candidly.
Oh, some of our greatest justices never tried a case. Roger Trader came right out of the law school in Berkeley, and he was probably California's greatest justice ever. And he is considered one of the two most influential state court justices of the last century, and the other one being Benjamin Cardozo, who,
right?
So those are the things that I would.
Fair enough. Well, we are out of time.
But yeah.
We are. I presumptuously will play Chief Justice and tell you you're out of time. Thank you so much for your time, and thank everybody in the audience who joined this unique session. Mm-hmm. And with that, we're going to sign off, and I'll just remind everybody that you should be receiving your CLE certificate within 24 hours. Thank you very much.